Welcome to the STARS program, seniors taking active roles in society. And now, here's your host, ANITA FINLEY.
Now, we've been waiting, holding our breath for Joe KARP, our elder law attorney. Good morning, Joe.
Good morning. I hope I keep the string of interesting guests going.
Well, if you want to talk about Marilyn Monroe, you know, that would help. But that's all right. We had that at 5 o'clock with Darwin Porter, and, you know, we had a lot of good things. But you do bring something that it's unusual. We don't have anybody that talks about how important it is for people to understand what their legal rights are as they age. So you can just take it. You know, your article coming up to discourage challengers, how you create your estate plan, and it's important what's in it. Of course it is.
Is as important as what's in it, but how you create it, what goes down, we are, as we know, a litigious society. For those of you who that's too early for, it means we like to sue people a lot.
Yeah, darn it.
We like to sue people a lot. And one of the growing areas of law is suing over estates. And it's interesting when you start to think about it. First of all, there is the inherent dislike that many siblings have for each other. I mean, the kids didn't all get along. And then they married people who have their own agendas. And everybody, you know, we go back to Cain and Abel, right? Well, we go to the Smothers Brothers. Mom always liked you best. And throw money into the mix. And when there is an estate that's been done, and sometimes when it's even equal, there are lawsuits over what would you perceive to be why are they suing? And there are so many reasons that people do it, and all the psychological garbage that floundering in people. And then there's just money and greed. And therefore, there are tons of lawsuits over estates. And the first step of making sure that the estate plan is solid is making sure that the circumstances under which the plan was created doesn't lend itself to an immediate challenge. So people are saying, what the hell does he mean? Okay. Mom comes into the office. Mom makes an appointment or an appointment's made for mom, and she wants to do her will or do her trust or change it. Frequently, mom comes not alone, and mom is widowed or single, and shows up with a child. That child automatically wants to come into the meeting. And the answer is, we tell people you cannot come in. In fact, maybe 15 years ago, Anita, I wrote a column for Boomer Times called Why the Waiting Room.
I do. I don't remember that particular column, but I know you've been a very proponent of this.
Well, that column, by the way, I have copied, and I keep that in my waiting room. And I let people read that this is not personal, this is protective. There's a number of reasons. I want to make sure, number one, that when mom comes in, I want her alone. I want to find out why she thinks she's here. What does she want to do? Because if she's going to do things that are going to lend themselves to somebody being pissed off because of the way she did her plan, and sometimes the pissed off is even just she's going to make Sophie in charge of the trust, no longer William. And there's a number of reasons, but we want to have those conversations in private. So number one, we can ensure that we believe she wants that. That two, if there's ever a contest, I always tell people when they get upset over that, and I say, look, if there's ever a lawsuit over the fact that, and frequently, by the way, there's a daughter living in Delray, the mother lives in Boynton, and it's the daughter living in Long Island who flies in and takes mom to the lawyer's office. So it already smells, you know? How come the non-local one took her? And it's because the non-local one is the one who is the go-to person in the family. It has nothing to do necessarily with any malevolence or any bad behavior. She's just the one who does stuff. She gets on top of it. We know those people. You're one of those people, okay? You're a doer.
Right.
So that daughter comes and we say, you have to stay out now. My mother wants me in. I say, I understand, but I've got an ethical responsibility to your mother. So one, we want to make sure there's a privileged conversation, because maybe she gave the brother $50,000 or $5,000 and she doesn't want the daughter to know about it. Then we also want to make sure that if there's a contest down the road, I always say, if there's a contest, I won't be the lawyer in the lawsuit. You won't? Hell no. I'm going to be the witness. I'm going to be the one who said I talked alone to mom. I'm the one who's going to say the daughter had to stay outside, and mom told me why she was doing all of this, where the daughter had no ability, at least in my office, to attempt to control what was going on. That's important so that we can do it. And obviously when you're then setting up who gets what, you do it so that even just the execution of the meeting, the initial meeting, and the meeting for the execution, we review it with mom alone. Then, if it's appropriate, we'll bring the daughter in after the decisions have been at least laid out once and the understanding of why they're going to do it. Now, sometimes that initial meeting with mom takes 2 minutes. She says, I moved down from New York. I want to update my power of attorney. My daughter's in charge, followed by the other one. I want to do a Florida document. I want to do this or that. And there are no changes and there's no inconsistencies and everything is honky-dory and you get the picture in 5-10 minutes and you bring the daughter in. But sometimes you hear the story and you don't want the daughter giving her feedback. In my column this month, we talk about a woman who came in who was our client. And she remarried, second marriage, and her husband insisted on coming in. Insisted. He wanted to make sure, she said, he's getting everything and her kids are cut out.
Oh, my.
He said, that's what she wants, and I want to make sure she gets what she wants.
Oh, Joe.
Okay. And we said, you have to wait outside. And finally, he said to the receptionist while we were sitting in with her, I need to see my wife right away. He was texting her feverishly during the meeting.
Wow.
5 minutes into it, she must have had 12 texts.
My goodness.
He comes in, he barges in and said, this is bullshit. She knows what she wants, and you have no right to meet with her alone to discuss it.
Oh, Joe, this is powerful.
I said, well, I don't have a right, but I have a duty. Mrs. So-and-so, I wish you luck, but I cannot do your estate plan. And then I documented I said, we're going to have to terminate our relationship. You want to do what you want to do, you're going to do it elsewhere. And I would not be surprised if she predeceases her husband, if her kids, and we keep records and notes, so we know that her relationship with her kids was good. If her kids end up suing and challenging the estate, and by the way, it sounds like to me appropriately, because I could not glean from her what she really wanted to do in the limited time we spoke. And if those kids end up coming back to us or their lawyer when they're suing the estate, if I'm called as a witness, my notes are clear cut. This lady was clearly under undue influence.
Wow.
Now, so we want to make sure the scenario is set so that we can protect the client, because she said, because sometimes they come in and they say, My daughter in Boynton Beach hasn't visited me in 3 years. This one flies down once every 6 weeks to see how I'm doing. She cares about me. She takes care of me. I want to leave her more. Well, that's fine. That's appropriate. But I have the reasons. I have the notes. I have the knowledge. But I didn't have that daughter in the room. So that's part of it. The second part is, for all you self-helpers, is to make sure everything is done legally, properly, and kosher. Are the estate planning documents signed in compliance with what the law requires? Merely because you have it written out and it says what you want, if it's not properly executed and not properly signed where the witnesses are present and there's documentation of that, and the witnesses sign in the presence of each other, and all of that good stuff, then the will is of no value anyway, or the trust is of no value. Or if you take your existing documents and say, well, I'm no longer going to leave my granddaughter any money, I already gave her money, and you just cross it off the document, that has no bearing. In fact, all it does is confuse everything and lead to another lawsuit. So these things have to be done technically correctly as well. And the number of people we see that do things technically incorrectly is frightening when they try to do it on their own. And they're being penny wise and pound foolish. They're trying to take care of it because it's no big deal. It's just this. It's just that. And it's not. It's your estate. So what goes into these documents is very important. I had a client we just signed documents with in a nursing home on Thursday. He was in for rehab, legit rehab. He's totally cognitive and aware. His 2 kids called up and said, this is what Dad wanted to do. And we had him call us from the nursing home and rehab facility, and he said, yes, that's what I want to do, but I have some thoughts. I'm not sure I want to do this. I'm not sure I want to do that. So we said, okay, we'll do it, but what we're going to do is prepare options. So when we meet with you, you can decide what you want, and you can elect to do either of the ways we've discussed, or if we have to, we can even do some crossing out, initialing, and handwriting in to make sure it's in compliance with your desires. The son called up, outraged, that we were giving the father options. He said he wanted to be present telephonically when we were meeting with the father to review everything.
Oh, my God.
And I said, there's attorney-client privilege. I have to make sure. And by the way, the son wanted to take control over the father's trust. And that father was not game for that. In fact, so it got a little complicated. But the son wrote back and said, you are our family's attorney. And I wrote back and I said, no, I am your father's attorney. I don't represent you at all. I said, I'm looking out for his best interest, and I want to make sure he knows what he's doing and he gets what he wants. And the guy is totally competent. He's a retired lawyer, about 90 years old, sharp as a tack. And, when I first spoke to him over the phone when he wanted to do the changes, he was still post-operatively a little groggy. So you didn't know for sure who you were getting, and he was going to be leaving the state for some other procedures for a period of time and wanted stuff done now. So we did it that way. But people don't get it. Our job is to protect our client and a part of our job is to make sure the client understands what the client is doing and what the client wants. I had children come in. It's actually a daughter and a son-in-law come in the other day where the mother came in and she had moved to Florida to be near her daughter. She had a son in Buffalo, New York, who lived 15 minutes away from her, who never visited, and a son in Colorado who never visited when she was in Buffalo. She moved down to Florida. She put her daughter in charge, and she said, I want my daughter to have everything. And she said, and I want no problems with the estate when I die. I said to her, well, if you want no problems, you got to leave it in thirds, because you've already described your children. They're going to come out from the woodwork because they're already pissed off that you moved to Florida to be near your daughter. And she said, you know, you're right. It's not that much money. I'd rather there be no hassles. Okay? And sure enough, 3 years later, and the daughter had brought her to the office, waited in the waiting room, didn't know what we were doing until after she said what she wanted, and she said she wanted the daughter to be in charge, but everything was equal. And the daughter looked to me at the meeting and said, thank God, how did you get her to agree to that? Because the daughter wasn't in it for the money. She didn't want a fight. Her brothers were pissed off at her already because Mom moved to Florida. They immediately thought it was all about the money rather than Mom's care. And she came in because she got a letter from her brother 3 years later saying, I want to know what's going on with Mom's money. And I gave her some advice as to how to deal with that through a third-party family member. Don't deal with this angry man. And say, this is Mom's money. If you want to talk to Mom about her money, you can ask her. I'm not telling you anything. And I said, it's just tough luck. And if the time ever comes that there's a lawsuit, this guy's going to see that he is getting thirds. And and the daughter is handling the mother's money, but she keeps everything pristinely accurate. She keeps receipts for everything because we knew what was going on. So, but setting the groundwork is very important. What you put in these documents is important. Having it thought out, making sure there's somebody who's a neutral witness as to what you were attempting to accomplish. Because we don't put in the documents, I'm leaving 100% to my daughter. Say she wanted to do that. I'm going to leave 100% to my daughter because my two sons have not paid attention to me in my declining years when I needed the most help. You don't want to put that in a will or a trust.
No.
But, boy, you want that in the attorney's notes. You want that attorney to be able to say that. So when people think we're prying, and we find out some interesting stuff. I mean, everybody's family's got stuff going on, right?
Yep.
So it's important, and we try to make sure that people understand that when you're doing it, how you create it, not only what it says, but how you create it is critical. So that's the message of that one, Anita.
Well, I have to tell you, I'm laughing because besides my own simple thing, it wasn't that bad because you took care of it. But another person whom I've been close friends with, she had the same thing with a family. So do you get many times when people die and it just goes perfect with no problems?
Oh, yeah.
Yeah.
Most of the time, and I don't mean like 51%, I would suggest that we have done, without exaggeration, thousands of estate plans. We've had, out of those thousands, maybe over 25 years, maybe 5 to 10 have been challenged.
Oh.
Usually, well, because they're not going to get it on how we did it. Okay, we're clean as a whistle. We follow certain practices all the time. We always make sure the witnesses are in the room. We always make sure that the people sign it together. We always make sure that the lawyers are sure that the person knows what they're doing. But every once in a while, we'll have a disgruntled one. And one of the things we now, and when I say we now, for many years have been recommending, and it happened when I was new to the practice. I had a client, husband and wife. The wife ended up on Medicaid, and the husband had all of the money. The son had been estranged for 20 years. He had been totally estranged. But the father who was doing his will said, I still have to leave him something. He's my son. He said, I'll leave him, and this formula of Joe KARP's you've heard before. I'll leave him 10% or $50,000, whichever is less. He came and he said, I want to give him $50,000. And I said, suppose there's not $500,000 in your estate when you die. He said, you're right. I could die with $50,000. I wouldn't want him to get it. So we made it 50% or $50,000 or 10%, whichever is less. When he died, the son obviously had to be served. The son was entitled to an accounting of what there was, even though the daughter said there's more than 50,000, so more than 500, we'll give you the 50 grand. And he ended up challenging it because the last will he had seen 20 some odd years ago, he was getting half. And he said, obviously my sister was exerting undue influence, and he found in my opinion, the wrong lawyer. That's somebody who will take a suit just because she's getting paid, versus the right lawyer who would have given him a good analysis of it. And there was a lawsuit. And it just lingered, and I was not one of the lawyers in the suit. Again, I was a witness. And ultimately, though, what I've learned is when I have somebody who has somebody that they want to give something to, but they're a headache, I say take them out of the plan. What we should have done is the father should have set up a bank account with $50,000 payable on death to the son when he died.
Oh, right.
And said in his will and in his trust, I make no provisions for my son under these instruments for no reasons known unto myself. Then he wouldn't have been entitled to information. He wouldn't have been entitled to get involved. He could have automatically. It wouldn't have been an automatic. He was cut out. And the daughter could have then just said to the bank or sent a note to the brother, here's information on the bank. You have an account that dad left you money. But it's also, I mean, when you get some of these people, you send them, suppose you're leaving $1,000 or a nominal amount to somebody who's going to be contemptuous of it. Well, you got to send them notice. Suppose they don't want to sign a receipt that they got the money. They can clog you up forever. They can make life miserable for whoever's trying to handle the estate.
Right. Mm.
So we've gotten wiser over the years saying, you can leave that person something, but just don't leave it in the estate plan. Keep them out of the system. So should we talk about my upcoming workshops?
Yes, let's do that. Sorry, I don't have that in front of me.
I do.
Okay, good.
My wife wrote it down for me.
Good, she's so good.
We're doing our senior survival workshops. We're going to be talking about estate planning, estates, and Medicaid laws. Tuesday, June 25th in Port St. Lucie at the Port St. Lucie Holiday Inn. We start at 1:30. We usually end at 4. Wednesday, June 26th in Boynton Beach at the Courtyard by Marriott. That's on Congress Avenue between Gateway and Boynton Beach Boulevard. It starts at 1:30. The cookies are good, too, at all of these places. Show up early, wear a sweater. We start on time. I don't always finish on time, but I always start on time. So we start at 1:30, June 26th in Boynton Beach. And Thursday, June 27th at Palm Beach Gardens at the Marriott, which is right off PGA Boulevard and RCA Boulevard. In Palm Beach Gardens, same thing, 1:30 to 4. We take a break. For people who attend the workshops, there's a couple of things. One, you'll get a lot of information and update. Two, we will offer people who are there, if we believe we can help them, an opportunity to schedule a free consultation to review their existing estate plan or to create one if they have none or if theirs is totally out of date. Sometimes people don't realize how out of date their workshops, their documents are. They just don't understand that the tax laws have changed, and sometimes they're not just addressing the realities of what's going on. And we talk about that, and because their kids are going through divorces, they have all sorts of things that life complicates for us on a regular basis. So you want to make sure they're up to date, your powers of attorney, your health surrogate, or sometimes you're a married couple and you're taking a look and you realize that your husband's memory is no good. He's got some dementia. He should not be listed number one on your health care. He should not be talking to your doctors to make your medical decisions if you can't. So it covers the gamut of things because everything deals with it. Or what should we be doing in case we end up in a nursing home? What should we do? How can we protect our assets? And asset protection for nursing homes is not so the kids can inherit more. That's not my philosophy. It's really so that the money is there to enhance the quality of care of the people whose money that is, whether it's a husband and wife or the surviving spouse. How can we protect money so if I end up in a nursing home and it's costing $10,000 a month, and by the way, listeners, that is not an exaggerated figure. It is not an exaggerated figure. I'd rather have the government pay for some of it so my money can be used to give me some private duty care or pay for a private room or do the things that I need so that I have a quality of life or so that my spouse is not going broke while we're going through that. Longevity has brought us a blessing and has also brought the curse of long-term care needs.
You know,
so
Joe,
we do those workshops.
Joe, I just have to kind of talk about this a little bit. When you hear Joe's seminars, workshops, it'll be fascinating to you because he will cover so many aspects that you never very thought of. And he's been doing this for these workshops, 20 years? More?
No, more. The first workshop I did was April 1994.
Oh, my goodness. But he's
25 years.
Yeah, and they've been terrific. It's like he should have been a professor at a university because he talks in such an easy way to understand things, and he's very smart. He's very nice, and I just have to tell you, these are free. Please be sure to go and see them. So, Can I
give the website?
Yeah, let's do that.
KARPlaw, KARPLAW.com. Our toll-free number is 1-800-893-9911. The stuff is on the website if you would like to come see about the firm, see about the seminars, and when you show up, say Anita sent me.
Oh, you're so nice. Thank you, Joe. It's always wonderful to have you on our show, and we're going to definitely get together one day soon, right?
Soon. I sure hope. Okay, take care.
Thank you. Thank you, Joe. Bye.